There's also the matter of fact that he withheld Liliana from me on 8/30. But I do have some issues with Mr. Pike trying to alienate me from Liliana's doctors.
Anna indicated that she talked to social services at Kaiser. There is no social services at Kaiser. I spoke with them and confirmed that. So there has been no social worker involved. The case of CPS was closed. And as far as I was told with my conversation with CPS, that was actually the findings from my house. So it doesn't actually indicate where the case was being closed from in that letter. It just says that it was closed. And when I spoke to CPS, the lady told me they were the findings from my house. So I'm not really sure. It's all very confusing.
Okay.
I've been canceled 3 times now by the doctor and trying to have a conversation with him to find out what's going on. And apparently Miss Manley has been able to get a hold of him, but I have not.
So Ms. Manley, go ahead with anything you would like the court to know. I'm just first dealing with Mr. Pike's motion for adequate cause to change a parenting plan.
I had the social worker from Kaiser. She called me and we talked about the whole situation. And she said her only concern was Mr. Pike's behavior. And as far as the CPS report goes, that's the findings from the drug test and the investigation to my home that they did because of Mr. Pike's allegations.
So I have reviewed the filings from Mr. Pike. Had indicated he thinks that these are related to any investigation on his home. I don't find that to be accurate. I find that it's specifically addressed to Ms. Manley and indicates that her case is being closed with no findings regarding the allegations. I also understand Mr. Pike is asserting to the court that there is no social worker at Kaiser. I don't find that to be accurate, as there are text messages from the Ms. Childs, the quote social worker from Kaiser, specifically to Ms. Manley. So I think the totality of these circumstances, in addition to the prior concerns I've had with regard to Mr. Pike re-raising allegations that were already addressed by a GAL, is that I am going to deny the motion for adequate cause. I have filled that out. I'm specifically making a finding that there are not valid reasons to hold a full hearing or trial on the petition. The petition for adequate cause should be dismissed, and I have signed an order to that effect. So we're not going to hold any further hearings on the adequate cause motion. Oh, maybe I'll just. So let's move to contempt. When we were together in prior hearings, I'll just note specifically that Mr. Pike had moved for contempt findings against Ms. Manley. I had already denied that finding. They were not violations of the parenting plan. However, there was a contempt motion by Ms. Manley alleging back child support. What I have received is a response from the Cowlitz County prosecutor indicating that the child support arrears are owed to the state of Washington and not to Ms. Manley. So Ms. Looney, are you taking any position beyond what was already filed on August 29th?
No, Your Honor.
Okay. And I assume the state is not filing its own or has not filed a motion for contempt at this time?
We have not, Your Honor.
Okay. So Ms. Manley, I also, because of the state's filing and that the arrears are actually owed to them, I do not find you would be the proper party to bring this action. Therefore, I am going to deny your motion for contempt against Mr. Pike as well. Do the parties, as far as I can tell, that takes care of all the issues that have been in front of me for the last few weeks. Is there anything else the parties believe hasn't been addressed that you have previously filed and asked the court to address?
Yes. I also filed contempt regarding my attorney fees that was put in place on 6/7/2021 that Mr. Pike owes me, with interest that's now up to $1,240. There's also the matter of fact that he withheld Liliana from me on 8/30.
Let me get to the attorney fees. I'm not seeing. Oh, it's included in your child support contempt order.
Yes.
Well, give me a minute to get to the final judgment. Mr. Fike, have you reimbursed $1,000 in attorney fees?
No, I didn't know I was supposed to. When she filed that, that was the first I had heard of it. I never got any email indicating that I owed anybody money.
I'm looking to see, Ms. Fike, what date that you indicate the judge ordered.
It was 6/7/2021.
This was a contempt hearing.
Only thing, Your Honor, I was given at the end of that trial was after the order, her attorney had filed for additional reconsideration, and that was denied by the judge. And that's the only thing that I've received after the fact.
Yeah, so Ms. Manley, I'm going to deny that request, and it's not because I don't think that he doesn't owe you the $1,000, but what you're referencing in 2020 is a contempt order. So the court has already ruled on this issue. They held a contempt hearing on June 7, 2021, and specifically made a finding that he was in contempt for failure, or excuse me, yeah, they actually stated he was not in contempt, but they awarded you $1,000.
Was I there for that one? Because I don't remember that.
6/7/2021, yes. Parties present, Ms. Bliss was the attorney, I believe, representing Ms. Manley. You were present as the petitioner in the proceedings. Your guardian ad litem was there, and there was a deputy prosecuting attorney there, Ms. Wade. Okay, so I'm going to go ahead and deny Ms. Manley's motion, but Mr. Fike, that 2021 judgment is there. There was an actual contempt hearing already on that issue. Okay.
Okay.
And then Ms. Manley, you said your other contempt hearing or contempt motion is based on Mr. Fike withholding Liliana from you on, is it August 23rd?
It was August 3rd.
Sorry, that cut out. You're continuing to cut out.
There, sorry. It was on August 30th when he was ordered to take her to get her dental treatment done. And the treatment was not done that day. And instead, Mr. Pike took Liliana to his home and kept her all day.
I am also going to deny for contempt. In reviewing the pleadings, it does not appear that this has been an issue that has recurred. And it looks like Mr. Pike's likely explanation through his filings was his concerns about her safety and welfare. I'm not condoning the behavior in any regard. But I'm not going to find that it was debate. So I'm going to deny, but what I'm going to say is I will entertain future motions for contempt if now that Mr. Pike is aware that this court has specifically made findings that Ms. Manley is not in contempt, CPS has closed their investigation, and it appears from everything I have that the doctor's office is actually concerned about Mr. Pike's behavior, not Ms. Manley's behavior. If there are further incidents where Mr. Pike is not adhering to the parenting plan, I will entertain motions for contempt. Okay, anything else the parties need addressed on your matters?
Well, it is, I don't know if it's contempt per se, but I do have some issues with Mr. Pike trying to alienate me from Liliana's doctors.
Right, so let me just say this. This court is not in a position to solve every unfortunate family dynamic. I don't have a motion in front of me that in any way addresses. I have allegations that you believe that the doctors have said that he's alienating you from her care. If you want to file something that's an actual standalone for contempt on that issue, we'll address it, but that's not in front of me today.
Okay.
All right, thank you both. You're free to log out.
He shot and killed Ms. Tresorati's boyfriend right in the house where they all lived. And then he was arrested, put in prison, and then subsequently Ms. Tresorati's mother committed suicide. So